Hello everyone. We meet again to discuss on a very different topic and a continuation from the previous topic, that is basic structure doctrine. This video is again presented before you on behalf of Lakshya Academy. I am a faculty with Lakshya Academy for polity. Let us begin. Now, what is the basic structure doctrine or basic structure of the constitution? So let me explain you this by an example. Suppose we are in a room. Okay, now in a room, you might be sitting in a room only now, I hope so. So if you look around, what can you see in a room? You will see the floor, the ceiling, the four walls, and all the structure is standing upon certain pillars, right? Okay, now if you remove those pillars, what will happen? The entire room will collapse, right? And if you let the pillars remain as they are, we just change the color of these walls, we change the tilings of the floor, we do some POP restructuring on the ceilings, would the roof collapse again? No. Okay, so if we want to redecorate the room without affecting the foundation of the room, that is the pillar of the room, everything remains as it is, and in fact it turns out to be better. However, if we try to remove the pillar, the foundation of the room itself collapses. Okay, so similar is our constitution. Our constitution has 22 parts, 395 articles, 12 schedules, and 105 amendments. If we try, or rather, the parliament has been given the power to change certain features of this constitution. That means certain parts can be changed, they can be removed, new parts added. Okay, certain articles can be modified, new articles added, few articles deleted. So all these external renovatory aspects can be done. However, there are certain articles, certain parts which are foundations, just like the pillars were foundation of that room. Certain parts, certain articles, certain schedules, they are foundational to the constitution. If the parliament is empowered to remove those very foundation, the entire spirit of the constitution will collapse, just like the room will collapse if we remove the pillars. Okay, so out of those 22 parts, 395 articles and 12 schedules, 105 amendments, few are so important that we in the sense, the parliament cannot be given the power to remove them. Okay, because the entire meaning of the constitution will fall apart if the parliament is empowered to do so. But this was not made aware to the parliament when the constitution was framed and enforced in 1950. Okay, so 1950 में the parliamentarians, they only knew that article 368 empowers them to change many provisions of the constitution. Okay, so they started using it. Fine, and as per them, any part of the constitution can be amended, as we saw in the previous class. Okay, there are three methods to amend the constitution. One is by simple majority, other is by special majority, and then special majority and consent of half of the states. Please go through the previous slide before you turn on this one. So there are three ways to amend the constitution. So in 1950, as per the parliamentarians, all provisions of the constitution, all articles, all parts can be amended. Okay, as per article 368. So what happened was the very first amendment act, that is the first amendment act 1951 happened. Okay, now it related to or the first amendment act rather impacted the right of property of many people in the country. So it was challenged before the Supreme Court. Why? Because if the parliament does anything, okay, as per article 13 of the constitution, we can challenge that law in front of the court, and the court will decide whether this is as per the constitution or it is not as per the constitution. This is called as judicial review. Okay, so the parliamentarians knew that they could amend the constitution, so they enacted the First Amendment Act. However, it was not to the liking of certain people, so they challenged it before the court. Okay, then similarly this thing evolved. Okay, this was the prelude to what will happen in the course of time. So there came, first case was the Shankari Prasad case of 1951. Then came the Golaknath case of 1967. Okay, then the parliament drafted or enacted the 24th Amendment Act and 25th Amendment Act in 1971. then came the Kesavanand Bharti case, which was the final blow to this, tussle between the court and the parliament to set what can be amended, what cannot be amended, what is the limits to the power of the parliament to amend the constitution. Okay, so several cases were fought between the government and the Supreme Court to arrive at what is the foundation of the constitution. Okay, and finally the Vaman Rao case of 1981. Now let us understand what happened in the Shankari Prasad case. In the Shankari Prasad case, the First Amendment Act, which affected right to property of certain people, was challenged before the court. Okay, then the court said that Parliament has power to amend any part of the constitution, including fundamental rights. Now let us have a relook. First Amendment Act amended or impacted the right to property of certain people. That time, right to property was a fundamental right. Okay, it was not simply our legal right. That means we can own the property and etc. etc. It was a fundamental right. That means the state cannot take away the fundamental right with no reason. Fine. So in Shankari Prasad case, the First Amendment Act was challenged by saying that it affects our fundamental right. However, the Supreme Court gave the judgment that Parliament can amend your fundamental rights also. Secondly, the Supreme Court also ordered that amendments are not equal to laws. Therefore, they cannot be asked for judicial review. That means, see, if the Parliament or the state legislatures draft any law, we can take it before the Supreme Court and tell the Supreme Court that it is not as per the Constitution. Please cancel it. This is judicial review. Okay, but we can do this for ordinary laws. We cannot do it for what is written in the Constitution. Okay, so because the Constitution is the benchmark on whose basis we are judging whether this law is constitutional or not. If the Constitution itself is changed, like first you have the right to property, okay, and the Parliament drafted a law which snatched away your right to property, then you can challenge this law. However, now the Parliament has amended your right to property. Now, on what basis will you challenge? The Constitution itself says a different thing. So there is no benchmark to challenge that law. Okay, so there were two judgments, important judgments of the Shankari Prasad case. First, Parliament has unbridled powers. That means it can amend any part, any article of the Constitution. Secondly, if the Parliament makes some amendments, you cannot come to the court and say this amendment is not as per the Constitution, because amendments are not ordinary laws. They are constitutional laws. Okay. Thereafter, it was the Golaknath case. Again, this case came up, the tussle between the Parliament and the court and the right to property. Okay, in the Golaknath case, the 17th Amendment Act was passed, or rather challenged. In the 17th Amendment Act, there were certain acts which are added in the 9th schedule of the Constitution. That means these acts won't be able to be challenged before the Supreme Court under judicial review. Okay, so the Parliament had inserted certain laws in 9th schedule by using the 17th Amendment Act, okay, based on which we could not challenge those laws in the Supreme Court. So this was the Golaknath case all about. Now in the Golaknath case, the Supreme Court reversed its judgment. It said Parliament cannot amend fundamental rights. Now quickly we'll recall. In Shankari Prasad case, the Supreme Court gave unbridled powers to the Parliament that you can amend fundamental rights. But here, in the Golaknath case, Supreme Court revised its judgment. It said Parliament cannot amend fundamental rights. That means it cannot affect your right to property. Second, amendments are equal to law, hence they are under judicial review. That means if the Parliament wants to change any part of the Constitution, it can do so. And if the ordinary citizen of India wants to challenge that modification, okay, in the court, they can do so. So the Shankari Prasad judgment was totally reversed by the Golaknath judgment. Of course, these two judgments, that the Parliament cannot change their fundamental rights, and secondly, amendments can be challenged in court. It was not to the liking of the Parliament. Okay, so it was followed by passing the 24th and 25th Amendment Act. Now, what happened in 24th Amendment? We'll see that. And then subsequently, after the 24th and 25th Amendment Act, came the Kesavanand Bharti case. Now, let us understand the Kesavanand Bharti case. Mr. Kesavanand Bharti, he was the chief priest of a Kerala mutt in Edneer. Okay. Now, Kerala government also had passed certain acts which affected right to property, and temples own a lot of property in India. So, Mr. Kesavanand Bharti, he challenged those laws that you cannot take away my fundamental right, because Golaknath judgment had told, right, that Parliament cannot amend the fundamental rights. Right to property is my fundamental right. So how can the Kerala government pass such a law which will affect my fundamental right? So this is what Mr. Kesavanand Bharti challenged in the court. Okay. Then again in 1971, the 24th Amendment Act that the Parliament passed, it stated that Parliament can amend any part of the Constitution. And the 25th Amendment Act made by the Parliament inserted Article 31C. Now, what is 31C? It says that Article 39B and C to be enforced, Article 14 and 19 can be amended. Basically, please understand, after the Golaknath judgment was very, very much in favor of the citizens and not that much in the favor of the Parliament. Okay, it basically put a restriction on the powers of the Parliament to amend the Constitution. So the Parliament passed 24th and 25th Amendment Act, which regained, through which it regained the powers to amend the fundamental rights and to amend any part of the Constitution. Okay, so through the 24th and 25th Amendment Act, the Parliament tried to counter the judgment of the Supreme Court in Golaknath case. So the Parliament regained the power to amend any part of the Constitution and without the need to judicial review. Okay. Now, Kesavanand Bharti, as I told you, he was the priest of Kerala Adnir Mutt. Now, in this judgment, the largest ever bench of Supreme Court sat. That means the 13 judges bench sat. 9 were in favor of this judgment, 4 disagreed. Now, what was the judgment? The judgment said, okay, Parliament will have power to amend any part of the Constitution. However, it cannot go against the basic structure. That means the foundational structure of the Constitution. I hope so it is understood. So, beginning from the Shankari Prasad case, then going to Golaknath case, and then the Kesavanand Bharti case. See, the basic structure doctrine actually evolved, right, through a tussle between the Supreme Court and the Parliament over whether the Parliament's power to amend the Constitution is unlimited or it is limited. So, in the Kesavanand Bharti case, the basic structure doctrine came up, in which the Supreme Court accepted that Parliament has power to amend the Constitution. However, the foundations cannot be removed, and those foundations were called as basic structure, and the doctrine came to be known as the basic structure doctrine. Okay, so Supreme Court upheld 24th and 25th Amendment Act, that is, the Parliament can amend any part of the Constitution, but it also said it can amend it only till the basic structure. So if we are sitting in a room, we can renovate the room as we like, but we cannot remove the 4 pillars of the room because the entire room will collapse. Similarly, the Parliament can amend any provision of the Constitution, but not the foundational provisions of the Constitution. I hope so this basic structure concept is clear. Okay. Now, so the Parliament asked, what is the basic structure? So Supreme Court said it will be decided from case to case. Okay. Now, in several cases of the Supreme Court has said that this comprises of the basic structure: supremacy of the Constitution, sovereign, democratic, republican nature of Indian polity, secularism, separation of powers, federal character of the Constitution, then unity and integrity, welfare state, judicial review, freedom and dignity of individual, parliamentary system, rule of law, harmony, principle of equality, free and fair elections, independence of judiciary. So these together actually comprise the basic structure of the Constitution. Now, these are certain more aspects of basic structure. I hope so you can go through them yourself once you see all the slides. So I hope so, students, this is well understood. What is the basic structure? Basic structure doctrine actually evolved from several cases, and it was finalized in the Kesavanand case that Parliament has the power to amend the Constitution. However, it cannot touch the foundational features of the Constitution, which will be decided by the Supreme Court from case to case. So I have listed before you some 20 to 21 elements of basic structure doctrine. I hope so it is clear enough to you what is the basic structure, what is the basic feature, what are the basic features of the Constitution very well through the slide. Please go through the slide again, revise the slide well, and we'll meet again for another session on certain topic of polities later. Thank you. See you all. Bye bye.